You wanted to do it like the other way. Or with the things.
No, not.
Yeah, that's fine.
Is that way on?
Yeah. That's fine, that's fine.
You send that page over?
I did, Your Honor. I sent all the instructions.
You got it, Kim?
No, I sent it. What's your email?
Send it to me. Send it to me.
It's just page 12.
Page 12. In cyberspace. Untitled. Tubes is. Who's J? Who's J?
Correct.
Yes.
Yeah. Okay, we ready for the jury to come out?
Hey, Charlie.
Yes, we're ready.
All right, let's bring them out. You know, there's not a place in the instructions to actually tell them to read them the verdict form, so.
Leave it. Of course, I can live that.
That's what I'm
Got the
thinking.
verdict form.
I'll figure it out. Okay, thank you. You may be seated. And welcome back, members of the jury. Members of the jury, I will now be reading you your final instructions. As you recall, same procedure from the guilt phase. The instructions that I read to you, I'll be reading from this hard copy, which will go back with you to the jury room. In addition, the instructions will appear on the monitors in front of you. Please don't read ahead, but follow along as I read these instructions to you. Members of the jury, you have heard all the evidence in the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. 1, life imprisonment without the possibility of parole, or 2, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are 1, Russell David Tillis was previously convicted of a felony involving the use or threat of violence to another person. The crimes of kidnapping and child abuse are felonies involving the use or threat of violence to another person. 2, the first-degree murder was committed while Russell David Tillis was engaged in or was an accomplice in the commission of any kidnapping. 3, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. 4, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Joni Gunter. 5, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection and not an act prompted by emotional frenzy, panic, or a fit of rage. Calculated means having a careful plan or pre-arranged design to commit murder before the fatal incident. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact amount of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, although insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family of Joni Gunter. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Joni Gunter's death. However, You may not consider this evidence as an aggravating factor. Your decisions must be based on the aggravating factors, the mitigating circumstances, and the weighing process upon which you will be instructed later. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. Excuse me. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more of aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor, and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1. As a child, Russell David Tillis watched his father beat his mother repeatedly. 2. Russell David Tillis lived in constant fear from his father. 3. Russell David Tillis's father was a severe alcoholic. 4. Russell David Tillis's wife, Terrell Patzer, began a sexual relationship with Russell David Tillis's father in exchange for reduced rent, and became pregnant by him while Russell David Tillis was in prison. 5. Russell David Tillis was introduced to drugs and alcohol at age 13. 6. Russell David Tillis used illegal drugs and alcohol before the age of 18. 7. Russell David Tillis was an accomplice in the capital felony committed by another person, and his participation was relatively minor. 8. Russell David Tillis attempted suicide in 2016 in the Duval County Jail. 9. Russell David Tillis was severely beaten by his father with belts and other instruments. 10, Russell David Tillis experienced extreme childhood trauma that would affect his ability to make good adolescent decisions, which set the trajectory of his future. 11, Russell David Tillis suffers from mental illness and possible neurocognitive disorders caused by drug use and head injuries. 12, Russell David Tillis sustained a head injury after being struck by a steel beam while working as a crane operator. 13, Russell David Tillis' mother failed to protect Russell David Tillis from his father because of her own sexual and physical abuse at the hands of Russell David Tillis' father. 14, Russell David Tillis rode motorcycles and mini bikes and was hospitalized several times after accidents in which he was not wearing a helmet. 15, Russell David Tillis acted under extreme duress or under the substantial domination of another person. Excuse me. 16, Russell David Tillis made a porch rail for his disabled neighbor. 17, Russell David Tillis fixed the plumbing for a neighbor's elderly mother. 18, Russell David Tillis had his own construction company renovating houses, First Coast Home Upgrading Incorporated. 19, the capacity of Russell David Tillis to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. 20, Russell David Tillis has 3 adult children. 21, Russell David Tillis took care of a sick mother on her deathbed. 22, Russell David Tillis evicted his father from the home when his mother was ill so he would not abuse her any longer. 23, Russell David Tillis has attempted to better himself in prison, taking available courses. 24, Russell David Tillis would work his skilled trades in welding and maintenance while in prison to the benefit of the Florida Department of Corrections. 25, the capital felony was committed while Russell David Tillis was under the influence of extreme mental or emotional disturbance. Excuse me. 26, Russell David Tillis provided a safe haven to Ms. Hogg, who was a heroin addict. He picked her up from jail, gave her money for commissary, and visited her while she was incarcerated. Russell David Tillis was very concerned about her heroin drug addiction. 27, Russell David Tillis provided legal help in the jail to inmates who did not have representation or who needed help understanding their legal process. 28, since 2004, Russell David Tillis has not received any disciplinary referrals, DRs, while incarcerated, meaning he has not been accused of any violence in custody in over 17 years. 29, Russell David Tillis collected toys and gave them to disadvantaged children in the neighborhood. 30, Russell David Tillis was anally raped by his father when Russell David Tillis was a child. 31, when Russell David Tillis was 12 years old, his mother instructed Russell David Tillis and his brother Claude to lock themselves in the trailer in the backyard while she was sleeping so their father could not rape them. 32, Russell David Tillis has a 38-year-old son, Nathan, who would like to establish and maintain a relationship with his father, which will be impossible if his father is dead. 33, Russell David Tillis gave his maternal uncle, Roger Hartley, a place to live for a year when he fell on hard times. Mr. Hartley was extremely grateful. 34, Russell David Tillis' son, Russell David Tillis Jr., is currently serving in Okinawa in the United States Marine Corps. 35, Russell David Tillis had a meaningful childhood friendship with Timothy Pendergrass. 36, Russell David Tillis took in Mr. Pendergrass after Mr. Pendergrass's wife threw him out. 37, Russell David Tillis lacked stability, safety, and security in his early childhood development. 38, Russell David Tillis is a Buddhist and practices meditation. 39, Russell David Tillis is appropriate, well-behaved, and respectful during court proceedings. 40, Russell David Tillis loves his 3 children. Russell David Tillis' drug addiction and extreme childhood trauma contributed to him not being a good father. However, he wishes to establish relationships with all his children. 41, the age of Russell David Tillis at the time of the crime. Russell David Tillis is currently 60 years old. 42, mercy can be given to Russell David Tillis. 43, Russell David Tillis is a human being. 44, Russell David Tillis' childhood trauma caused him to have a low opinion of himself throughout his life. 45, Russell David Tillis' abusive childhood led to his self-medicating with drugs. 46, Russell David Tillis being raped by his father caused anger, erosion of self-worth, and confusion of sexual desires. 47, Russell David Tillis has impulse control deficits that were caused by head trauma and substance abuse. 48, Russell David Tillis's abusive childhood created high risk factors for violent behavior. 49, there was never a meaningful intervention to protect Russell David Tillis from the violence and abuse he suffered as a child. 50, Russell David Tillis's school records reflect low performance, and he dropped out of school in the 8th grade when he was 14. 51, Russell David Tillis led a double life, evidenced by periods of sobriety and employment, followed by periods of drug addiction and criminal behavior. 52, Russell David Tillis lacked nurturing from either parent to develop emotionally and cognitively in a healthy manner. 53, Russell David Tillis's mother chose her husband over her sons, even when her husband was abusing everyone in the family. 54, throughout his life, Russell David Tillis cared deeply for his mother and tried to protect her from his father. 55, Russell David Tillis experienced toxic stress and toxic shame, and there was no meaningful intervention to alleviate the stress associated with the shame and trauma. 56, Russell David Tillis's drug use impaired his function and reduced his impulse control. 57, Russell David Tillis's abusive childhood and associated drug use stunted his psychological development and caused permanent damage to his brain. 58, in childhood, Russell David Tillis was abused, neglected, and abandoned by adults who were supposed to protect him. 59, the repetitive trauma Russell David Tillis suffered as a child caused him to live in a constant state of anxiety and fear similar to that of people living in war zones. You as jurors can consider any other mitigating circumstance that you may find appropriate. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweighs the mitigating circumstances that you have found individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if Council, approach for a moment. Okay, members of the jury, I apologize. I was missing part of one paragraph, so I'm going to read that last. I'm going to start at the beginning of the last paragraph. So I apologize. I'm going to read a few lines over again, but I think it's appropriate to start over here. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweighs the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous, and your decision to impose a sentence of death must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence, and I'll go over that form with you in just a few moments. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that's inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or of a misdemeanor involving dishonesty or a false statement? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there's no other evidence tending to agree with what the witness says about the defendant. So, while a witness of that kind may be entirely truthful when testifying, you should consider their testimony with more caution than the testimony of other witnesses. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The following are some general rules that apply to your discussions, and you must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. Your decision must be based only on the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits, and these instructions. Your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decisions. Your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decision must be based on the evidence and the law contained in these instructions. I think now would be appropriate for me to, before I read the last final instructions to you, to go over the verdict form with you. So if we can go forward, there we go, to the verdict form. And it's quite lengthy. It may seem confusing, but I think as we go through it, and more importantly, as you have it with you back in the jury room, you'll see that how it flows. It starts out, of course, it's got the style of the case, the State of Florida versus Russell David Tillis. A, aggravating factors. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to Russell David Tillis in this case. Then it says 1A, Russell David Tillis was previously convicted of a felony involving the use or threat of violence to another person, kidnapping. If the jury unanimously, each individual juror, as well as the jury as a whole, unanimously finds that that aggravating factor exists, you would check yes. If the jury does not unanimously say yes, then you would check no. Same for 1B. Russell David Tillis was previously convicted of a felony involving the use or threat of violence to another person, to wit, child abuse. If the jury as a whole, as well as each individual juror, unanimously finds that that exists, you would check or an X there. If not, it's no. 2, the first-degree murder was committed while Russell David Tillis was engaged in the commission of a kidnapping. Again, if you're unanimous yes, you check that. If not, no. 3, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. Again, each individual juror, as well as the jury as a whole, says yes. You check yes. If not, the answer is no. 4, the first-degree murder was especially heinous, atrocious, or cruel. If the unanimous decision of the jury is yes, check or an X there. If not, no. 5, first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. If the answer to that unanimously is yes, that's the check or an X. If not, no. So, if you answer yes to at least one of the 5 aggravating factors listed above, you would then proceed to Section B. However, if you answered no to all 5 of those, you do not proceed to Section B. The defendant is not eligible for the death penalty and will be sentenced to life in prison. At that point, you would sign and date the verdict form and return to the courtroom. If you move on to Section B, sufficiency of the aggravating factors. Reviewing the aggravating factors that we unanimously found to be proven beyond a reasonable doubt in Section A above, we, the jury, also unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. If the decision of each individual juror, as well as the jury as a whole, is yes, you would check yes. And if you answer yes, you'll then go to C. If you check no, you will not proceed to Section C. The defendant will be sentenced to life in prison. You'll sign and date the verdict form and return to the courtroom. Under Section C, mitigating circumstances. We, the jury, find that the following mitigating circumstances have been established by a greater weight of the evidence as to the defendant, Russell David Tillis, in this case. Now, for this, since it doesn't have to be unanimous, jurors should put the number of yes votes and the number of no votes under each mitigating circumstance. And I recognize that there's a large number, but you need to go through each one of those. And there were 59, as I recall. And I'm not going to repeat them. I read them to you once. You have them in front of you on the verdict form. You'll go through them, and you'll take a vote, and then you'll put the vote on for each of those. Okay, regardless of whatever findings you make for the 59 potential mitigating circumstances, you will proceed to Section D, eligibility for the death penalty. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A above outweigh the mitigating circumstances established in Section C above. So if you unanimously find that your aggravating factors outweigh the mitigating factors as outlined in this section, each individual juror as well as the jury as a whole unanimously finds that. You will place a check or an X next to yes. If not, no. And if you answered yes, then you'll proceed to Section E, but if you answered no, there, you do not proceed. The defendant will be sentenced to life in prison. Please sign and date the verdict form and return to the courtroom. Section E, jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A above, that the aggravating factors are sufficient to warrant a sentence of death in Section B above, and that the aggravating factors outweigh the mitigating circumstances in Section D above, we, the jury, unanimously find that the defendant, Russell David Tillis, should be sentenced to death. Yes or no? And you will check one of those boxes. If your vote is no, if you have checked no, your numeric vote to impose a sentence of life imprisonment is as follows. Obviously, your sentence, if you vote for a sentence of death, that must be 12-0. If you vote, if you're not unanimous for death, whatever your vote is for life, you must place in that section there. Number of votes for life, number of votes for death. If your vote to impose a death is less than unanimous, the trial court shall impose a sentence of life, and then sign and date the verdict form. And the only markings that should be on the verdict form should be the ones that we have discussed. In just a few moments, you will be taken to the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communications, such as a blog, Twitter, email, text message, or any other means. Obviously, your cell phones will remain outside as we have been doing throughout the course of the trial. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of this instruction or any other instruction I've given in this case, you must let me know by telling one of the bailiffs. During the trial, items were received into evidence as exhibits. Those will go back with you again. And there were some new exhibits during the penalty phase as well. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. As before, if you need to communicate with me, send a note through the bailiff, signed by the forepersons. I will need to talk with the attorneys if you do have any questions. Of course, it takes time to gather everybody together. And as before, you may continue with your deliberations while you wait for the answer to whatever question that you may have, and I'll try to answer any questions here in open court. And as I told you before, let me remind you that it's important that you follow the law set out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For over 2 centuries, we have agreed to a constitution and to live by the law, and no juror has the right to violate the rules that we all share. With that, as before, we appreciate that our alternates rejoined us for these proceedings. Our original 12 appear alert and ready to deliberate. Our 3 alternates, do any of you have anything back in the jury room? No? Okay, if you will remain right there, I'll speak to you guys in just a moment. And our other 12 jurors may now retire to deliberate. Madam Clerk, you can have these.
Your Honor, that page 12 actually has a whole paragraph that,
Yeah, I don't know how that happened.
I think it was because that was the page where the additional line.
Do we know what page that was? I think I can find the one Ms. Miller gave me because I know it had a little tear in the corner, but. Give that back. Other than what has been discussed, any objection to the instructions as read?
Not from the state.
Okay. Once again, I cannot thank the 3 of you enough for your participation. You know, it's been 2 weeks. I don't want to say I'm surprised that we haven't needed one of you to step in, but in a way I am, because usually in 2 weeks something happens, some kind of emergency or time issue or something. Fortunately, that did not occur. But I've tried to keep a close eye on all 15 of you, and I know all 50, the 3 of you especially, paid close attention. It may have been difficult during certainly the penalty phase, because at that point you knew you were an alternate, which you didn't necessarily know during the trial. You know, serving on a jury is, you know, even if it's a one-day DUI or burglary trial or something like that, is a massive undertaking. Just from not just a time frame, but from an emotional standpoint. But serving on a jury of a case of this type takes a lot out of you as a citizen, and we know that. But I hope you found the experience interesting. You are welcome, as I told you before, to stay and see what happens. Normally, a penalty phase deliberation is not as long as a guilt phase. But again, you have no way of knowing. I probably jinxed it. You know, it could take 2 days. But whether you leave or whether you stay, know that you leave here with all of our thanks for spending 2 weeks down here on a very emotional and trying case, and that your service was not for no reason whatsoever, because you could have been asked to step in at any time whatsoever. So with that, you are now free to go. Thank you very much. And we will remain in session until Madam Clerk has returned back to the courtroom. Okay, Madam Clerk has returned. We will be in recess awaiting word from the jury. If you leave the courtroom, make sure Madam Clerk knows how to get a hold of you. We will be in recess.